Hello, my name is Zach McGee. I am the chairman of New Media Legal Publishing, the sponsor of the CLE program you are about to watch. This program was recorded a few years ago, but we've confirmed that the content is still current and reflects the present state of the law on this topic. I hope you enjoy it.
Hello, I'm Peter Afrasiabi, and I'm excited to talk to you today about this Curious Lawyer program entitled CIA Law. We have it all today for you: Manchurian candidate programs, JFK's assassination, sunken subs, the outing of CIA agents, and even the origins of the famed phrase, "We can neither confirm nor deny." As you walk through this area of law today, you will find that your pop culture understanding of the CIA and the legal system that regulates it may be very, very different to the actual legal system that is in place. And so, I hope you enjoy this fun, whimsical walk through CIA law. The first slide we have here really is a look at the CIA's family tree, its lineage and history, so to speak. The origins of the CIA started in 1941, and at the time the name of the agency was the Office of the Coordinator of Information. It was a World War II created office to deal with espionage and intelligence gathering for the war effort, established in July of 1941. In 1942, it was renamed the Office of Strategic Services, which many of you have probably heard of the acronym OSS. That was renamed a couple of times, and in 1947, the name Central Intelligence Agency, or CIA, was officially coined in the U.S. Legal Code. That brings us to the next slide, which gets us to 1947 or so. And so, after World War II, there were congressional hearings to address the events of Pearl Harbor, how it happened, and deficiencies in American intelligence gathering, and how the country could remedy that with a new legal framework. And so, these hearings in Congress led ultimately to the enactment of the laws that we'll talk about in a moment. And it's really the tragedy of Pearl Harbor and the country's ability to gather and analyze intelligence that became a critical issue, both in peacetime and war, that the Congress decided had to be improved. And so hearings were convened in 1947, and you can see on the next slide, we have a couple quotes from Fleet Admiral Nimitz, who testified in the Congress in 1947, where he said, "Intelligence is a composite of authenticated and evaluated information covering not only the armed forces establishment of a possible enemy, but also his industrial capacity, racial traits, religious beliefs, and other related aspects." Similarly, Alan Dulles testified in 1947, saying, quote, "American businessmen and American professors and Americans of all types and descriptions who travel around the world are one of the greatest repositories of intelligence that we have." Those are some very fascinating sort of bedrock footprints that were laid down as Congress held hearings to decide about the enactment of new laws. And on the next slide, you can see the new law was the National Security Act of 1947. Codified at 50 U.S.C. Section 403, and today it's codified at 50 U.S.C. Section 3036. And the key here was to gather, keep secret, and protect. And so, what the NSA Act of 1947 did was to establish the CIA as a new agency of the United States government and to empower it, among other things, quote, "to correlate and evaluate intelligence relating to the national security." It was also responsible for coordinating intelligence activities relating to national security. And it specifically provided that the director of the CIA, the Central Intelligence, is responsible for, quote, "protecting intelligence sources and methods from unauthorized disclosure." And that section becomes very important, as you'll see as we start walking through some of the secrecy case law in a moment. So, as we see on the next slide, today we have really two major sources of federal law that govern this sort of overarching control over the CIA and what it may and may not do. The first, of course, is the United States Code we just looked at, which is the Congressional Detail of Responsibilities. But it's very, very thin, so to speak. It doesn't have a tremendous detail. The real detail, the nitty-gritty, comes from executive orders. And the most significant statement on the CIA's operational obligations and the limitations on what it can do really begins with President Reagan's executive order of 1981. This is Executive Order 12333. It's been modified significantly by President Bush in the post 9/11 war years, and then again by President Obama when he took office. And that executive order is one of the most important areas to go to look at the nature of what the CIA may and may not do. Let's start, however, with the US Code in terms of what it says are the responsibilities of the CIA. And you see here on the next slide that the CIA's responsibilities are to collect intelligence through human sources and other means, except that the CIA shall have no police, subpoena, or law enforcement powers, nor any internal security functions within the United States. This is a very important gatekeeper limitation, and it demarks the line ultimately between intelligence gathering, which is the role of the CIA, and law enforcement, domestic law enforcement, which is the role at the federal level, of course, of the FBI and other organizations. The second responsibility here is for the CIA to correlate and evaluate intelligence that relates to the national security, and also ensure the appropriate dissemination of such intelligence to the appropriate executive officials, the president and other appropriate agencies. Third, we see that the CIA is responsible for providing overall direction and coordination of the collection of intelligence outside the US through human and other sources, and also to work in coordination with other departments of the US government to gather this information and make sure that it is done in the most effective and risk-free manner. And finally, to perform such other functions and duties related to intelligence affecting national security as the President may direct. Very, very broad mandate, as you can see there. This brings us to the executive order. And the executive order is a very long document. It's well worth reading. It's a fascinating read in terms of understanding what the CIA can and cannot do. And it spells out the priorities and objectives in really tremendous detail. And here on the next slide, you can see some of those objectives spelled out, and these come from sections 1.1, 1.5, and 1.8 of the governing and cited executive order. The first one, to provide the President with the necessary information on which to base decisions concerning the conduct and development of foreign defense and economic policy. To detect and counter espionage and other threats and activities by foreign intelligence services against the United States. To come up with policies concerning foreign intelligence and counterintelligence arrangements and such relationships within the intelligence community. And then also to conduct counterintelligence activities outside the US for the benefit of the United States. Then this is really interesting, and it brings us to the next slide, which are the actual definitions of counterintelligence, covert actions, and electronic surveillance. You can see here that the definition of counterintelligence in section 3.5 means information gathered and activities conducted to identify, deceive, exploit, disrupt, or protect against espionage, other intelligence activities, sabotage, or assassinations conducted for or on behalf of foreign powers, organizations, or persons, or their agents, or international terrorist organizations. Covert action means an activity or activities of the U.S. government to influence political, economic, or military conditions abroad. And electronic surveillance means the acquisition of non-public communications by electronic means without the consent of the person who's a party to the electronic communication. All of this brings us now to the beginning of our walk through the CIA and what it may do. And we're going to start with spy games. And this is the question of domestic spying. What can the CIA do here in the United States in terms of spying on U.S. citizens or others within the United States? Well, federal law speaks to this, as you see. And it specifically says that spying activities abroad are well within the CIA's charter. But the question is domestic spying. And here, the executive order is very clear that the CIA shall not engage in electronic surveillance within the United States, except for the purpose of training, testing, or conducting countermeasures to hostile electronic surveillance. Those are three incredibly broad gerunds or verbal nouns there: training, testing, conducting countermeasures. The scope of those words has not been tested in any litigation or any courts, so it really remains for future litigation to understand the full scope of what it means to be allowed to engage in domestic electronic surveillance for training purposes or testing purposes. But nonetheless, the general architecture of this law is that the CIA is not supposed to engage in any domestic spying activities, but for those limited exceptions. The next slide, as we can see, is that the FBI is the organization with domestic jurisdiction for intelligence gathering, and the CIA has a limited role in assisting the FBI where national security is at stake. And so here again we see the executive order that authorizes the CIA to cooperate with domestic law enforcement agencies to protect the facilities of those in the intelligence community. In other words, it can do domestic work in conjunction with domestic agencies. And the second and third prongs there are similar. The CIA can involve itself in domestic work where it's trying to prevent foreign clandestine organizations, intelligence operations of foreign countries or organizations that are operating in the United States. The CIA will go head-to-head with them here domestically. And of course, there's the broad catch-all there at the end that the CIA may render any other, quote, assistance and cooperation to law enforcement or other civil authorities not precluded by applicable law. A very broad mandate that can have a lot of breathing room, one would suspect. Again, that phrase has not been litigated either. So from spy games, we are now going to move to secrecy law. And secrecy law part 1 we're going to discuss right now is the law of refusing to confirm or deny. This brings us to the case of the alleged CIA secret research ship known as the Glomar on the high seas. So this takes us to the 1970s, and there was a series of newspaper articles about the ship known as the Hughes Glomar Explorer, a ship allegedly owned by Howard Hughes and his organization. And it was a massive ship out in the ocean. It was a sort of a vessel that was publicly listed by the Hughes organization as being a research ship. But it was one of the largest ships in existence. And Hughes alleged it was for his ocean mining business and operations. But these newspaper articles published in the 1970s actually contended that it was really a secret government CIA ship involved in some sort of secret nefarious activities out on the high seas. And so this resulted, as these leaks came out, in some journalists issuing some Freedom of Information Act requests on the CIA. The CIA got those demands to find out about, the Glomar and whether the CIA was involved in using the Glomar for some reason, what reason, and what the CIA's role was. And the CIA sat down with one of its lawyers and came up with a response. And the response was as follows. The fact of the existence or non-existence of the records you request would relate to information pertaining to intelligence, sources, and methods which the Director of the Central Intelligence has the responsibility to protect. In the interest of national security, involvement by the United States government in the activities which are the subject matter of your request can neither be confirmed nor denied. That was the first time, actually, that the response, we can neither confirm nor deny, was issued by the CIA. And it has now become known as the Glomar response. That very famous phrase that's a part of our pop culture actually originated in a FOIA request in a legal battle with the CIA. So, as you can hear in this clip that we're going to play, there's a fascinating little bit of history from the lawyer who came up with the phrase. And so we'll now play the clip for you.
Journalists had figured out what had happened in this mission. There were too many leaks. It was impossible to keep the secrecy. So they had to come up with this sort of thread-the-needle response to Freedom of Information Act requests. And I spoke with the attorney. He didn't give us his real name. He gave us a pseudonym, Walt Logan. But I spoke with the attorney at the CIA who came up with the response, which is still used by a lot of government officials today. Here's Walt Logan.
The Glomar response developed was basically the following. We can neither confirm nor deny the existence of the information requested. But, hypothetically, if such data were to exist, the subject matter would be classified and could not be disclosed.
We can neither confirm nor deny. That's certainly a familiar slogan or familiar response.
Remarkable clip there. The result of the case ultimately was that the court held that the CIA could stand on that objection and not produce any responsive information given the national security exceptions to the Freedom of Information Act laws. For our young lawyers listening today, that's an incredible example of how, in what's often mundane discovery efforts, you may be able to create a phrase that will become part of not just legal culture, but the pop culture itself. Imagine if you, as you craft your discovery responses, you may be the next architect of some famed phrase that will live in infamy forever in the annals of discovery law and the case law. Who knew discovery could be so much fun? And of course, if you do it for the CIA, as you saw in that example, you must remain anonymous. The original author of that phrase, the lawyer working for the CIA, we don't know who he is exactly. As we turn to the next slide, we can answer the question, what was the story behind the Glomar? Well, it's all come out now, and it turns out it really was all true. The CIA built this massive ship, and it went to Howard Hughes and asked him to sort of, in effect, be a front for the CIA's efforts to take this massive ship out into the ocean and try to retrieve a sunken Soviet nuclear sub that was 3 miles down in the ocean, and this ship was used to help try to raise that sub. It's been the subject of some fascinating books, all of which are outside the scope of this program, but it's well worth a read if you want to learn more about the CIA and the Glomar ship and the sunken Soviet sub. This brings us to secrecy part 2, access to CIA records. We're going to walk through 3 different case studies now that really address in more detail the secrecy issues that came up in the Glomar case, and that is the issue of access to CIA records. And this leads us, of course, to a deeper examination of the Freedom of Information Act and where it collides with the CIA and the National Security Act that governs the CIA's mandate. The first case we're going to look at is really the case of Cold War biologic programs focused on really trying to control people. And I put a picture up here of the Manchurian Candidate poster because it really is Manchurian Candidate stuff that seems to have been at work here. And so what came out is that between 1953 and 1966, the CIA was indeed financing a wide-ranging project that was codenamed McUltra, and it was concerned with the research and development of chemical, biological, and radiological materials capable of employment in clandestine operations to control human behavior. That's a quote from the Supreme Court case that ultimately looked at this issue. And so McUltra was established as a program to counter perceived Soviet and Chinese advances in brainwashing and interrogation techniques. And over the years, the program included various medical and psychological experiments, some of which apparently led to rather untoward results. And all of these aspects of this McUltra program surfaced publicly during the 1970s and became the subject of various executive and congressional investigations. So, this then brings us to the next slide, and it's entitled CIA versus FOIA, where the two collide. And so we have to look at 2 different bodies of federal law here to understand their interplay. The first is the Freedom of Information Act. And the Freedom of Information Act, of course, at a very general high level, provides that various government agencies, in response to public requests for information, need to open their kimono, so to speak, and share what records they have in their files. Of course, subject to a variety of very important limitations. One of the limitations within FOIA itself is known as Exemption 3. And Exemption 3 of FOIA provides that an agency, such as the CIA, of course, does not need to disclose, quote, matters that are specifically exempted from disclosure by statute, provided that such statute refers to particular types of matters to be withheld, end quote. So you have that language in FOIA, and then you've got the actual National Security Act of 1947 that states, quote, the Director of Central Intelligence shall be responsible for protecting intelligence sources and methods from unauthorized disclosure, end quote. The question then that this Manchurian Candidate type program raised is, what is the interplay of these 2 statutes? Is that quoted language from the 1947 statute language that triggers Exemption 3 of the Freedom of Information Act, or is it not? All of this then gets teed up in a court battle, and the court battle is known as we see on the next slide, CIA versus Sims. And this is a case that ultimately went all the way to the United States Supreme Court in the 1980s, starting, of course, many years earlier. And so it started when, after these articles about these sort of human experiment type programs came out, you had some researchers and lawyers that went to the CIA and filed some Freedom of Information Act requests. And they wanted information on this program. And by this point, the program had sort of entered congressional investigations, and it was well established that it actually did exist and had occurred. And so the CIA didn't issue its GLOMAR response and just neither confirm nor deny. It simply stood on Exemption 3 and said, we refuse to produce anything because to produce anything could endanger our intelligence sources and methods, and that's a carve-out under the National Security Act, which triggers Exemption 3 of FOIA. And the district court, in this case, agreed. The district court held that yes, that Exemption 3 of FOIA applies and the CIA doesn't have to produce any of these records. The researchers appealed, and actually the Federal Court of Appeals reversed and said that Exemption 3 did not apply and that the national security statute didn't trump the Exemption 3 language as the two interplayed together in this sort of legal jigsaw puzzle, and so accordingly concluded that the CIA actually needed to produce all of those documents. This, of course, caused the CIA to take the case up to the U.S. Supreme Court, hence the case entitled CIA versus Sims. Before the Supreme Court, however, the case was reversed yet again. And as you see here, the Supreme Court articulated the rule, and the rule is as follows. Congress intended to give the Director of Central Intelligence broad power to protect the secrecy and integrity of the intelligence process. The reasons are too obvious to call for enlarged discussion. Without such protections, the agency would be virtually impotent. Really, really broad language there that's fascinating to see in a judicial opinion. And so the court obviously then held as a result that the director of the CIA was well within his statutory authority to withhold the names of the researchers and information about this McCultra program. And the lasting quote from the Supreme Court is that, quote, this forced disclosure of the identities of the intelligence sources could well have a devastating impact on the agency's ability to carry out its mission. The government has a compelling interest in protecting both the secrecy of information, important to our national security, and the appearance of confidentiality, so essential to the effective operation of our foreign intelligence services. So ultimately, this case shows the balance between sort of the First Amendment and press access and free, transparent access to government records on the one hand, and the CIA on the other, and how when dealing with the CIA in light of that very broad language from the 1947 National Security Statute, these FOIA requests generally fall on the side of the CIA in terms of protecting information from public disclosure. And that's a very different result to the nature of FOIA and FOIA requests against other government agencies in other contexts. Fascinating footnote to this history about these Manchurian candidate type programs. In President Reagan's now governing executive order on the CIA that was issued in 1981, there's actually a provision, Section 210, entitled Human Experimentation. And it provides that no element of the intelligence community can sponsor, contract for, or conduct any research on any human subjects unless they comply with Department of Health and Human Services and also make sure they secure informed consent. That's the current standard of the law. Because of the Sims holding, of course, we'll never know, at least for a long time or unless there's any leaks one day, what was the exact nature of that McCultra program. This brings us to our next case, which is the case of alleged CIA involvement in JFK's assassination. This case is entitled Minier versus CIA. You find it at 88 F. 3rd, 796, and it's reported by the Ninth Circuit in 1996. So, this is the backstory. A man named Claude Barnes Capehart died in 1989. And before he died, he claimed to have been a CIA agent, and he claimed that he was involved in the assassination of President Kennedy in Dallas in 1963. This, of course, prompted researchers, many research, but one in particular, David Minier, sought by a Freedom of Information Act request particular records from the CIA. Minier went to the CIA and said, I want to know whether Capehart ever worked for you. Was he a CIA agent, in fact? And number two, I want to know where Capehart was on November the 22nd, 1963. You can imagine the CIA lawyers when they received that request. Well, their response was what you expected. It was the Glomar request. We can neither confirm nor deny. This brings us to the next slide and how the court handled the Glomar response. The Ninth Circuit opinion is a fascinating opinion to read. I highly recommend you go read it. In fact, I quoted a large portion of the holding here for you because it's such a remarkable piece of writing to read from a federal appellate court, one of the, the third branch of government, co-equal branch of government. And so the Ninth Circuit begins, certain historical facts are unassailable, while others are constantly subject to attack and ultimately remain shrouded in mystery and confusion. Both types of facts surround the assassination of President John F. Kennedy. We know beyond dispute that on November 22, 1963, President Kennedy was tragically shot and killed while traveling through the streets of Dallas, Texas. We also know that a single individual, Lee Harvey Oswald, was arrested and portrayed to the public as the sole assassin. I find that statement itself remarkable coming from a federal court and a branch of government because it itself shows a remarkable sort of perception about the two different kind of factual records that seem to exist in the public lexicon, at least, about JFK's assassination. And so the court then continues, over the past 30 years, however, many people have debated the accuracy of the sole assassin theory, positing that one individual could not have accomplished the task alone. Although many conspiracy theories have been generated through the years, the most infamous theory alleges CIA involvement in the assassination. Really remarkable piece of judicial writing and a fun piece of writing for the court, no doubt, to have written. Nonetheless, what the Ninth Circuit ultimately held, however, was that the CIA may withhold all information that it has or does not have about this alleged CIA spy and where he was under the near blanket Exemption 3 of the Freedom of Information Act request. And so, as it stood, Exemption 3 permitted the CIA to refuse to either confirm or deny the existence of any employment relationship between itself and the alleged CIA agent, Mr. Capehart. As a result, it also followed that because the CIA was allowed to decline to acknowledge the existence of his alleged employment, it also was entitled to decline to disclose any alleged CIA activities during November of 1963 in Dallas because, as the Ninth Circuit found, the release of any such information would tacitly reveal whether Capehart had an employment relationship with the CIA, and it would also provide a window into the CIA's sources and methods. So, as it stands today, we don't know whether Mr. Capehart was involved in the assassination of President Kennedy, and that remains for future WikiLeaks or whatnot. This brings us to our third case study, which is involving access to Vietnam War daily presidential briefings. And these presidential daily briefings are something that you probably know of from popular culture and the cultural lexicon in terms of the daily requirement, or the belief that it's a daily requirement, that the CIA brief the president on high-level issues affecting the national security. And so this presidential daily briefing practice actually dates back to John F. Kennedy's administration, and very few of these presidential daily briefings have ever been released to the public. And so one day, Larry Berman, he was a political science professor at University of California, Davis, he files a Freedom of Information Act request, and he wanted two very specific President Johnson-era presidential daily briefings. He wanted the presidential daily briefing that was given on August the 6th, 1965, and also one on April the 2nd, 1968. And the CIA received these requests and then refused to produce the presidential daily briefing, citing national security information and, again, the same intelligence sources methods exemption to the FOIA statute. The Ninth Circuit got the case and held, first of all, that the CIA actually had the burden to prove that this exemption was triggered. It couldn't just claim the exemption sort of in a vacuum. It needed to actually factually come forward with some sort of proof that the exemption was triggered. That, you may think, could open the door then to the question of how much information does the CIA have to give in order to prove the existence of the exemption, and if it gives sufficient information to prove the existence of the exemption, it may have now automatically tripped over the very exemption it's trying to stand behind. And that was the issue that was then litigated up to the Ninth Circuit. And the CIA in this case actually produced a declaration from one of its employees asserting that national security was at stake. And the plaintiff's position was all the CIA offered was sort of inadequate ultimate conclusions, devoid of any factual basis to really test whether this exemption was triggered. But the Ninth Circuit said not so. And here's a long quote that's worth indeed reading, because it kind of gives you some insight into the level of detail given by the CIA that the Ninth Circuit held was absolutely sufficient to trigger the exemption. The CIA explained that the daily briefing had sensitive, important information that only the CIA had on that given day. It explained how it would identify intelligence sources and methods. It explained how the release of this would contextualize information and could ultimately reveal sources. And because it's a daily type release, it would be very, very fresh in terms of the information. Those types of statements. The plaintiff was screaming and yelling that that's my point. Those are all, ultimate conclusions and don't actually explain why these two presidential daily briefings would actually trigger such an inquiry. The Ninth Circuit didn't hold an in-camera hearing and demand more detail to look under the hood, so to speak. And so as it stands, that type of a statement by the CIA will suffice to deny researchers, lawyers, you, the viewer, access to these CIA records from presidential daily briefings and others. The next slide is kind of a tip here and a practice pointer ultimately, and that is that this near blanket FOIA exemption for CIA records really does seem to exist, and the Ninth Circuit in that case literally used the quote, near blanket. It's unclear actually, how it's not a total blanket and what's the difference between near and total. If there's a sliver of sunlight, the case law hasn't found it yet. And so my conclusion after surveying all the case law comes to a very practical piece of advice. Don't even waste your time asking. That's how hard it is to get CIA records. And no, I don't work for the CIA secretly. I can confirm that. So I'm not trying to stop you from serving a FOIA request on the CIA. It's just very hard to get information from them. This brings us to part 3 of our secrecy discussion today, and this involves legal prohibitions on disclosing the names of CIA agents. We start with the next slide, which is the Intelligence Identities Protection Act. This is codified at 50 U.S.C. 3121. And subsection A of 3121 is entitled Disclosure of Information by Persons Having or Having Had Access to Classified Information that Identifies Covert Agent. And so what it provides is that whoever, if you've had authorized access to any classified information that identifies a covert agent, if you intentionally disclose such information identifying such covert agent to any individual not authorized to receive the classified information, where you know that the information disclosed so identifies the covert agent and that the United States actually takes affirmative measures to conceal the covert agent's intelligence relationship to the United States, that person shall be fined and also imprisoned up to 15 years or both. So that's the Intelligent Identities Protection Act. There's other substantive provisions that are very, very similar, but the core rule here is that the names and identities of CIA agents operating abroad or domestically are secret and they need to stay secret, and it's a federal crime to release them. So let's now look at how all of this plays out in the real world. And this brings us to the most recent case of CIA agent Valerie Plame and Ambassador Wilson. It's been immortalized in a movie entitled Fair Game. You may have seen the Hollywood production of this with Naomi Watts and Sean Penn starring as Valerie Plame and Ambassador Wilson, respectively. It's a fun Hollywood movie to go watch. But it's built on a real set of facts and a real set of cases, actually, that trigger this CIA secrecy law that we're going to talk about. And it begins with the 2003 State of the Union address by President George W. Bush. And there were 16 critical words that triggered this whole avalanche of case law and litigation that we're now going to look at. And those 16 words you see on the slide here are as follows. The British government has learned that Saddam Hussein recently sought significant quantities of uranium from Africa. Those 16 words really did set off a firestorm, and I'm going to have you watch this short clip right now to kind of get the full backstory of what came out of this as a result of those words and the Valerie Plame and the Ambassador Wilson involvement. So here's the clip.
We met the most famous spy in America in Santa Fe, New Mexico, where she moved with her family earlier this year, and she wanted to clear up some misconceptions.
When I was outed on July 14, 2003, I was, until that moment, covert.
And that means what?
That means that no one outside of a very small circle knew where I really worked.
She believes her identity was leaked in a newspaper because her husband, who had gone on a fact-finding mission for the CIA before the Iraq War, publicly accused the president and others of lying to justify the invasion.
We understood that he would be criticized deeply. I never once considered that, in fact, this administration would betray my identity as payback for his criticism.
What went through your mind when you saw your name in print?
Oh, it was horrifying, absolutely horrifying.
Horrifying because Valerie Plame Wilson was no glorified secretary. In fact, as it's spelled out in her new book, Fair Game, published by Simon & Schuster, which is owned by CBS, she spent 20 years at the CIA, rising to top-level positions. Her assignments took her all over the world, where she gathered information, recruited spies, and worked for many years deep undercover. In 1998, she was working at headquarters, spying for the newest CIA division, counter-proliferation.
And our mission was to make sure that that the bad guys basically did not get nuclear weapons.
By the time her name was leaked in 2003, she was chief of operations for the CIA's Joint Task Force Iraq, in charge of dozens of officers and analysts. It was before the Iraq War, and she was trying to find evidence that Saddam Hussein had weapons of mass destruction. This didn't sound so far-fetched to you at the time.
No, not at all. It's not as though Saddam Hussein had not pursued this and had not used WMD on his own people.
You and your team were meeting with Iraqi scientists before the invasion.
Mm-hmm.
What kind of intelligence were you getting from those people?
Thin, very patchy.
Could it be you just weren't getting enough intelligence at the time?
Exactly, that was the horror. You didn't know if maybe if you just found the right scientist, if you just got to the right person, he would be able to give you the plans or give you, really critical stuff that would help put all these pieces together.
One of those pieces was of particular interest to the vice president's office. An intelligence report saying Iraq was buying 500 tons of uranium ore, which can be used to build nuclear weapons, from the African nation of Niger, a report that later turned out to be based on forged documents. In early 2002, Valerie Wilson says an officer from her task force got a call from one of Dick Cheney's staffers, asking the CIA to look into the allegation.
And just as we were talking and pondering this, another colleague of mine came by, overheard us, and he said, well, what about Joe? Why don't we send Joe?
Send Joe, as in her husband, former Ambassador Joseph Wilson. When it was brought up, did you think, that's a reasonable idea?
Well, yes, because Joe has the independent credentials to do this. He knew Iraq and Saddam Hussein. He had served many years in Africa. He had, in fact, knew the governments, the different governments of Niger.
He was, in fact, gone to Niger for the CIA before.
Yes, he had done some missions, yes.
So her CIA superiors dispatched him back to Niger, where he concluded the uranium sale was highly unlikely. That was March 2002. Almost a year later, during the State of the Union, President Bush uttered these 16 words.
The British government has learned that Saddam Hussein recently sought significant quantities of uranium from Africa.
So, as you see, as a result of all of this, Ambassador Wilson started publishing some editorials, was very concerned about what he believed were misstatements to justify the war against Saddam Hussein. Valerie Plame was then, her name was outed and released as an agent, bringing an end ultimately to her CIA career. And this then results in a series of cases. And the first case we're going to look at is the case of Wilson versus Libby. And this is Ambassador Wilson and his wife, Valerie Plame, who sued Scooter Libby, one of the executive officials in the White House, allegedly involved in the release of Valerie Plame's identity. And this was a civil lawsuit for alleged constitutional violations of their privacy rights under Bivens. And here they were seeking an actual damages remedy against Vice President Cheney, Scooter Libby, and other officials for violating that federal statute we looked at earlier, the Intelligence Protection Act statute, and other secrecy laws about her covert identity and what she had done for the CIA. And in this case, the court held that there is no damages remedy available to Ambassador Wilson or Valerie Plame as a remedy for money, and instead, to the extent there's any sort of civil remedy for the outing of Valerie Plame and for any invasions of privacy that occurred, that was subject to some federal Privacy Act statute that's the exclusive remedial regime to look to seek any kind of financial remuneration. And so the result of this ultimately is that the violation of the statute can occur, and it does not lead to a financial remedy for the victim, the CIA agent who has been outed. There may be other remedies that we'll look at that occur for the person engaged in the illegal conduct, but at least vis-a-vis the CIA agent who's now been outed, there's actually no financial remedy available for them under federal law against those federal officials, because the Privacy Act was the sole place they could look to, and as it turns out, most of the defendants were exempt from liability under the Privacy Act. So it kind of creates this fascinating conundrum at some level that there are criminal penalties because of the massive national security interest in protecting agents, but there's no express civil right of action for the agent who's now lost her career. Kind of fascinating kind of case of how it unfolds. But it's not the end of the story. It may be the end of the civil component of the litigation by Valerie Plame and Ambassador Wilson, but there was another component to the case, and the case doesn't end here. So this brings us to the next case, which is the criminal case of United States versus Libby. And it's a fascinating criminal case, actually, because what happened is, as these investigations were unfolding, there was a criminal prosecution. And it was a criminal prosecution brought against Scooter Libby and some others for interfering with the special prosecutor and lying to the FBI in the FBI's criminal investigation into this whole Plame affair. In other words, as all these stories unfolded in the press, it became clear that a CIA agent had been outed. That was a violation of federal law. The FBI began an investigation, interviewed a whole variety of witnesses at the CIA, in the executive White House, to try to figure out what happened and, was there a leak, where did it come from, who did it, etc. And in that context, the charge was that Scooter Libby lied to the FBI when they were asking him about his involvement in this whole Plame affair, and ultimately obstructed justice. And so he went to trial, and after a long trial, he was convicted and actually sentenced to 30 months. Now, he then received a presidential pardon from President Bush, and as a short footnote, if you want to learn more about presidential pardons, I've got another Curious Lawyer series on presidential pardons that you can watch. It's a fun little footnote to learn all about presidential pardons. In any event, what's particularly interesting here is that Libby obviously received his pardon, but he wasn't actually charged under the IIPA or other federal espionage laws that form the basis of the whole underlying original special investigation. His only charge was perjury and obstruction of justice. This brings us to Secrecy Part 4, Balancing the First Amendment with the CIA. We've been through 2 pieces of litigation that spawned out of the Valerie Plame affair, and now there's a third one. And so on the next slide, you see we're now on the case of In Re Grand Jury Subpoena of Judith Miller. It's reported at 438 F. 3rd, 1141 from the DC Circuit in 2006. And again, it brings us back to the Valerie Plame and Ambassador Wilson affair. And so this is what happened. Time and the New York Times both ran articles about the whole outing of Valerie Plame, sort of based on that video clip that you just saw, that part of the story. There were then grand jury proceedings that were convened, and those led to subpoenas that were issued to journalists at the Time and New York Times magazines and newspapers. The subpoenas wanted to know who are the sources that had outed Plame or told you things about Ambassador Wilson and his trips. The journalists refused, citing the First Amendment, claiming that they had a First Amendment right to protect their sources and they did not need to comply with these subpoenas. This went before the district court, and the district court found that no, there is no First Amendment right to protect your source when the source was involved in violating potentially, or could be relevant to learning, who violated the secrecy laws around identities of CIA agents. And so the district court ordered the journalists to identify the sources. The journalists refused and were held in contempt of court. This then went on appeal to the Court of Appeals for the D.C. Circuit. And the D.C. Circuit made 4 very, very important holdings. You see them here. The first is that the grand jury's authority to subpoena witnesses is not just a historic incident, but essential to its actual task. And so the court set the stage by focusing on the paramount importance of the grand jury being able to sift through the facts and get to the bottom of what really happened, irrespective of any journalist alleged privileges. The second point is that grand juries and courts operate under the longstanding principle that the public has a right to every man's evidence, except for those persons protected by constitutional, common law, or statutory privilege. The D.C. Circuit then held that the only testimonial privilege for unofficial witnesses that is rooted in the Constitution is the Fifth Amendment's guarantee against self-incrimination. And so the result of that was that the D.C. Circuit refused to find that the First Amendment provided some sort of a journalist privilege that would trump the CIA's IIPA, Intelligence Identity Protection Act law, that sort of CIA protective law that exists. And so ultimately what the court held is that the Constitution and the First Amendment rights that the journalists claimed didn't trump it, and that law prevailed. And so they had to produce the identity of the folks who they had spoken to. So on the next slide, you can see the net of all of this, and that is that the First Amendment protection for journalist secrecy and sources does not trump CIA secrecy mandates. And so journalists do not possess a constitutional right to conceal their confidential sources from grand jury subpoenas when it relates to outed CIA agents. Ultimately, the net of all this is rather unique. It's illegal to out a CIA agent. The laws against outing CIA agents are so important that journalists have to give up their sources and can't rely on any First Amendment secrecy protections. Yet at the same time, there's no damages remedy for the CIA agent who loses her career when she's outed. It's sort of a fascinating legal conundrum that's been created as all of these cases merge together. And this is a brand new area of law that hasn't been tested before all of these cases, and so these pieces are new in this puzzle. It's actually a remarkable thing to go look at that federal statute, the Intelligence Identity Protection Act, because it's unlike any other federal statute in this sense. When you go to the notes of decision in Westlaw, there's only 1 or 2 cases that have ever cited the statute, and these are the cases we just spoke about. So it's a statute that's been on the books a long time, but it's quite literally never found its way into the Article III courts until recently, stemming from those famous 16 words in the State of the Union speech. This brings us to part 5 of our secrecy series regarding CIA law, and that involves former CIA agents and their right to publish. This gets to the next slide, which is entitled Spies Keeping Secrets, the Publications Review Board. And so there's a very important detailed process, a legal structure and process that exists for former CIA agents in terms of being able to publish books or memoirs or articles. There's a contractual secrecy component to employees of the CIA, and that puts on them a lifelong obligation to maintain secrecy on all national security matters. And some of the reported language from case law in terms of their actual employment agreements are that They are not allowed to publish any information or material relating to the agency, its activities, or intelligence activities generally, either during or after the term of employment, without specific prior approval by the agency. How does your client, for example, if it's a former agent who wants to publish a book, how does he or she go about getting specific prior approval from the agency? Well, Spies Keeping Secrets has led to the creation of a publications review board within the CIA. This is a review board made up of current and former employees who, or it looks to current and former employees who have to offer their materials to the review board if they want to publish anything. And the review board both looks at the materials and decides whether those materials can be published. And it applies to oral discussions, written discussions, and even fictional works. So these don't have to be sort of personal autobiographical memoirs. It's a straight work of fiction. You know, if a CIA agent wants to write a James Bond-like novel, that has to be run through the publication review board of the CIA. There's a whole list of per se banned materials that can't be published or discussed as a result of one's employment with the CIA, and that involves discussions of military plans, weapons systems or operations, foreign government information, any intelligence activities such as covert actions, sources or methods, cryptology or confidential sources, scientific, technological or economic matters relating to the national security, United States government programs for safeguarding nuclear materials, any vulnerabilities or capabilities of any of our systems, and the development, production, or use of weapons of mass destruction, all of which are fully banned. So, the next case we're going to look at involves what happens when a CIA agent violates those secrecy norms, doesn't run the publication review board gamut, and instead publishes a book. And this case is entitled Snepp versus United States. It's reported at 444 U.S. 507, and it's from 1980. And the case takes us back again to the Vietnam War. And so here we have a former CIA agent who published a book about his various Vietnam War exploits that he did for the CIA. He did not submit his manuscript or his book to the pre-publication board of the CIA. Instead, he just published it. Now, the book, it turned out, did not contain any classified material, but nonetheless, the CIA filed a lawsuit and they secured a constructive trust on all the profits of the book, and they secured an injunction against any future violations. This case then made its way up to the United States Supreme Court, and the United States Supreme Court found that the obligation not to publish anything at all without clearance ahead of time from the review board absolutely permitted this really broad remedy of a constructive trust on all the book's profits, because the court held any publication may be detrimental to national security. Now note, the court specifically found the book didn't contain classified material, but nonetheless, this constructive trust could stand. And the quote from the case is as follows: "This remedy is the natural and customary consequence of a breach of trust. It deals fairly with both parties by conforming relief to the dimensions of the wrong. If the agent secures pre-publication clearance, he can publish with no fear of liability. If the agent publishes unreviewed material in violation of his fiduciary and contractual obligation, the trust remedy simply requires him to disgorge the benefits of his faithlessness. Since the remedy is swift and sure, it is tailored to deter those who would place sensitive information at risk, and since the remedy reaches only funds attributable to the breach, it cannot saddle the former agent with exemplary damages out of all proportion to his gain." So the result of your potential client not running the review board, all the money he or she makes from his book will land in the coffers of the CIA. So the best advice is you should always have your clients run through the CIA review board process to secure pre-publication, even when it's unequivocally the case that the material disclosed is simply not classified material and is kind of higher level general stuff. You don't want to invoke the ire of the CIA in this case law. Now, this gets us then obviously to the conclusion you see on the next slide, that courts will heavily punish any secrecy violations by the CIA or its employees, even when they disclose information that's not even classified. In other words, secrecy is king. So not only will there be a constructive trust, but a broad injunction prohibiting future violations and future behavior too, requiring conformance to the review board. This gets us to the last component of CIA law today, and that of course is torture. And part one of this is there a license to kill? Of course, the license to kill, you know from James Bond, it's the famous saying that MI6 agents allegedly possess. And actually, as it turns out, under United Kingdom law, it has been confirmed by United Kingdom agencies and even courts that there are certain circumstances under which MI6 agents, such as your modern day James Bonds and the like, do possess the right to kill in certain circumstances. The question, of course, for us here in this American CLE is whether the CIA and its agents ever have the right to kill. Is there an American license to kill? This brings us to the next slide. Our Executive Order 12333 again answers the question. Section 2.11, Prohibition on Assassination. No person employed by or acting on behalf of the United States government shall engage in or conspire to engage in assassination. And 2.12, indirect participation. No element of the intelligence community shall participate in or request any person to undertake activities forbidden by this order. So, the next slide, the answer to the question, there's no James Bond rule in America, there's no license to kill. This brings us to torture part 2, short of killing, and that, of course, is enhanced interrogation techniques, also known, of course, as torture. The legal framework, as you see on the next slide, is that it's a federal crime under 18 U.S.C. Section 2340, that's the Federal Criminal Penal Code, of course. It's a crime for a person outside the U.S. to commit torture or attempt it, and there's up to 20 years and even the death sentence or life in prison if the victim of torture dies. Torture is defined as an act committed by a person acting under the color of law specifically intended to inflict severe physical or mental pain or suffering upon another person within his custody or physical control. Severe mental pain or suffering means the prolonged mental harm caused by or resulting from the intentional infliction or threatened infliction of severe physical pain or suffering, the administration or application or threatened administration or application of mind-altering substances or other procedures calculated to disrupt profoundly the senses of the person or the personality, the threat of imminent death, or the threat that another person will imminently be subjected to death, severe pain or suffering, or the administration of mind-altering substances or other procedures calculated to disrupt their senses. That's the federal criminal framework that governs CIA operations abroad, in effect, when it comes to U.S. citizens in being involved potentially in torture. So this, of course, brings us to Al-Qaeda and the CIA and the post-9/11 world. And of course, there's the stories and now what's well known about the CIA and its capture of various detainees, and one of whom it captured and interrogated was a guy named Abu Zubaydah. He was a terrorist, and the government sought a legal opinion on his interrogation and the techniques, as the CIA firmly believed he was withholding information that was really material to stop future terrorist acts. And so this terrorist then, and the ability to gain information from him, was at issue by the CIA, and it was put to the Department of Justice and folks within the executive to ascertain whether he could be appropriately tortured or what was the scope of what could be done to him to gather information. And this, of course, landed in the hands of John Yoo and Jay Bybee at the Office of Legal Counsel in 2002, and these led to, from the Bush era, what are now infamously known as the torture memos. And there's a couple of them. There's the standards of conduct for interrogation under that federal criminal provision, and then there's, quote, interrogation of Al-Qaeda, and a memo for the General Counsel of the Department of Defense. And these were authored by John Yoo and Jay Bybee. The first one we see here is the Bybee memo and its conclusions, and it concluded that cruel, inhuman, or degrading treatment is not torture under that federal criminal provision. Instead, torture is serious physical injury such as organ failure, impairment of bodily function, or even death. And so the conclusion, of course, is that waterboarding was not torture. The other conclusion is that or was that prolonged mental harm as torture must be mental harm that lasts months or even years. That was the sort of definition of prolonged for the interpretation of that federal criminal statute. And finally, the conclusion was that any kind of a prosecution under that federal criminal provision could be barred because enforcement of the statute may indeed represent an unconstitutional infringement of the president's authority to conduct war. Those conclusions were memorialized by J. Bybee in August 2002, and you see on the next slide his famous memorandum's conclusions, and this is the actual memorandum we have here for you. And it's there where he says, for the foregoing reasons, we conclude that torture, as defined by sections 2340, covers only extreme acts. Severe pain is generally of the kind difficult for the victim to endure. Where the pain is physical, it must be on an intensity akin to that which accompanies serious physical injury such as death or organ failure. Severe mental pain requires suffering not just at the moment of infliction, but lasting psychological harm, such as seen in mental disorders like post-traumatic stress disorder. Because the acts inflicting torture are extreme, there is a significant range of acts that, though they might constitute cruel, inhuman, or degrading treatment or punishment, fail to rise to the level of torture. And so, of course, this distinction between torture and non-torturous but still cruel conduct became the predicate to facilitate and enable waterboarding and other behavior that then occurred. The U memo is similar. You see that on the next slide, and here's the conclusion. This was a memo issued by John Yoo from the Deputy Assistant Attorney General in 2003, where he concluded that the Fifth and Eighth Amendments do not extend to alien enemy combatants held abroad. We conclude the different canons of construction indicate that criminal laws do not apply to the military interrogation of alien unlawful combatants abroad, thereby facilitating and working hand in hand with the Bybee memo to allow a certain range of treatment of these enemy combatants. Now, this brings us to the President Obama era, where 2 days into his presidency, he rescinded all of that advice and those memos that you just saw quoted from the 2000 to 2008 time period, and he issued instead Executive Order 13491, entitled Ensuring Lawful Interrogations. The conclusion ultimately of that executive order is that waterboarding is illegal because it is torture. The next slide, of course, brings us to our sort of conclusion on all of this with respect to torture, which is, as it stands today, there's not to be any CIA waterboarding and other comparable enhanced interrogation techniques that rise to the level of torture. But what rises to the level of torture could certainly ping-pong depending upon the situation and depending upon what president's in power and what interpretations are given of the federal laws at this point. This brings us to the concluding portion of this program, where we will talk about legal myths about the CIA. The first myth: there's a license to kill. We've already answered that. The answer is no. There is no license to kill. It's a legal myth that the CIA can run around killing people. Legal myth number 2: there's mandatory presidential daily briefings. Actually, no. There is no mandatory presidential daily briefing. The conventional idea that's evolved in sort of pop culture and the media, and even within legal circles, is that the law mandates that the CIA run over every day to the White House and give the president, in some manner, a daily briefing on all the hot button issues going on around the world. You see it in The West Wing and Madam Secretary and all these different TV shows, and you read about it. But actually, as it turns out, the law does not, there is no federal law that mandates mandatory presidential daily briefings. That is, as it turns out, a legal myth and an urban legend that it's required. The legal history, however, to this specialized intelligence briefing dates back again to the administration of President John F. Kennedy, where President Kennedy, once he assumed the role of the presidency, actually asked the CIA to produce some sort of special briefing that would succinctly identify and summarize recently collected intelligence information that he may be interested in or his advisors may be interested in to help him execute the policy issues that he was focused on. That became known as the President's Intelligence Checklist, and it became a very important form of communication between the President and the CIA and the other apparatus of the intelligence community. When President Johnson took office, it became a daily briefing, and it became known as the Presidential Daily Briefing. And that's sort of been the custom as it's evolved over the years. But as it turns out, it is not required by law for the CIA director to daily brief the President of the United States on these things. It's just a custom that's evolved. The third legal myth, and our final legal myth that we get to, that you've probably heard about at some point, it's a funny one, but it's a good one, is that the CIA will never hire you if you've illegally downloaded any MP3s. For all of you who may have at one point in time used Napster or Grokster and ripped some music back in the early days of the internet, you'll never be able to be hired by the CIA. That's the sort of conventional understanding. But as it turns out on the next slide, it's a bit of a myth, and this is a direct quote from the CIA's website. This one's true and false. We understand that people all have made choices in the past that they don't make anymore, and as our laws have grown to prevent illegal downloading, so have our expectations of our employees. What we're looking for is honesty and adherence to the law from all active employees. So the conclusion is, ultimately, even copyright law collides a little bit with the CIA. It's not just secrecy, torture, the Manchurian candidate assassinations, and sunken subs. Even copyright law may be touching the CIA, and the CIA, at least by its account, is responsive and reflexive to the reality of the world, and may even recognize that, yeah, maybe you downloaded some music a long time ago, but you can still work for the CIA. That brings an end to today's program. I thank you very much for watching this latest in our series called The Curious Lawyer. I hope you've enjoyed this walk through the law that governs and controls the CIA and how it operates abroad and domestically with respect to a whole range of programs, including secrecy, the First Amendment, and the Freedom of Information Act. Thank you.